This conference will now be recorded.
Clock
Can
says it's 1 minute after 9.
I'd like to call the meeting to order. Good morning. I would ask the town clerk to please call the roll.
Chair Cody,
Present.
Vice Chair Hinton,
Present.
Member Bingham,
Here.
Member Cassidy, here, Member Sloat.
Present.
Okay, thank you. Would you all join me in saying the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Now I'd like to ask Carla, our town clerk, to explain the rules and procedures for selecting a chair and vice chair for this commission.
Hello, everybody. So essentially, after the commission reappoints or appoints members to the board, there has to be, per the code, a selection of a chair and vice chair. Per the rules of order and procedure that the commission adopted, you guys do have to vote by ballot. So essentially, you will ask for public comment, you close public comment if you guys want to deliberate amongst yourself about anything before I hand out the ballots, and you let me know whenever you all are ready for me to hand out the ballots and cast your vote. And it's going to be the same procedures for chair and vice chair. So after you're done voting for the chair, we'll proceed and pass the ballots for vice chair.
Okay. Is there any discussion, or do you want to go right to ballot?
I have a question. Would it be proper to ask what each member's view of the variance board is? And how they conceive the position and what we're supposed to do?
It's really at the chair's discretion if she wants to entertain a discussion before. Normally, it's just a straight ballot issue. We do have also later on the agenda today a discussion about the variance process and the criteria. But if it's something that you want to discuss before voting on.
I just thought it might make a difference as who you want to lead the variance board. I don't know, it was just I just threw that out there. Because I'm that way.
Anybody else want to talk about that or want to go to ballot?
Well,
Oh, and to the public as well?
Yeah, public comment.
Is there any public comment on the matter? All right, going back then to your comment, Betty.
Well, as I understand the variance board, it certainly isn't a popularity contest, because we have to decide whether what a person wants to do will not only is absolutely necessary for and the only way to accomplish what they're in, but also how it will affect the whole neighborhood and all of their neighbors. And that sometimes is a very difficult decision to make. Originally, when Ocean Ridge was incorporated, they had businesses here. They had restaurants, etc. They decided that it was going to be an entirely a residential community, low key, not to become New York or Miami, and rules and regulations. Planning and zoning were written in that direction. As I see it, it's our job to enforce the planning and zoning laws as nearly as possible, except in really adverse circumstances, not I want circumstances.
okay.
Does anybody want to comment or address what Betty's saying in terms of their own personal viewpoint? My sense is that we're all sworn to observe the rules of this quasi-judicial board and to adhere to the requirements in granting a variance. So it's somewhat of a subjective comment you want, right, in terms of our own philosophy. And I don't know how appropriate that is for this board, because we are charged with following the law. So I don't know how our own viewpoint would.
The law makes us make a judgment as to whether
But without
this is,
precedent.
we follow the law, but we don't set a precedent.
Yeah, they're
which is
unique.
Really important.
Yeah. Each variance is a unique situation unto
Correct.
itself.
Correct.
That's true, but we also have to decide whether it is the only way to do it and how it affects the other people in the neighborhood. Which is why I say it's
Agree.
not necessarily.
Yeah, but that's one of the criteria
Yeah.
we look at.
I hear you.
I just had a question, actually, for the town. The council evidently had voted that every time there's a member change, that we have to vote for new officers, right?
No, it's just every time, even if it's reappointment to the same.
Yeah.
After the commission chooses in May, there's usually an election of chair and vice chair at the first meeting of each committee, even if it stays the same.
Even if it stays the same, that was my
So
concern,
it's
you
an
know?
annual.
Yeah,
It's an
okay.
annual thing.
Well, I think, Betty, to your point, perhaps we could go into those kinds of attitudes when we have the discussion
Yeah.
with
My-
our attorney.
We can't discuss them between ourselves
Right.
outside. That's the reason I brought it to the floor here, where everyone is present to avoid the sunshine law.
Thank you. Does anyone, Carolyn, do you want to add anything or?
Well, I think it's important, a number of decisions that we've made have been made with conditions, and I think it's important, to address that in every case.
Mhm.
And
Madam Chair, if I might just add, the board's governed by Robert's Rules of Procedure. And under those rules, your chair is really supposed to act impartially in trying to find a consensus of the board, and trying to make a decision unanimous if possible. And so they certainly can have their opinion, because when the chair is also a voting member, they can certainly have an opinion. But initially, they're trying to find a common ground that the board will agree on. So whether you're going to take a hardline stance at the criteria and say, only in 1% of the cases you hear, are you going to grant a variance, or whether you're going to be a little bit more liberal with the criteria, really as a chair shouldn't come much into your, how you handle your duties as the chair. Obviously, it'll come into your decision, your own opinion, but as the chair, you're kind of in that impartial realm until it gets to your own personal opinion.
that's well stated. Thank you.
Yeah, I just thought it'd be a good time to air this.
Any other comments? Then I'd like to proceed, if everyone is in agreement, with the distribution of the ballots. Thank you.
Assume we've got a-
Here.
Okay, so. Did I miss one person?
You haven't got mine.
Oh.
I was waiting for you to wake up.
Thank you. That happened around like noonish. Okay, so there is 2 for Carolyn Cassidy and 2 for Bruce Hinton. And then 1 for Robert Sloat, so there is no majority, so we'll go on to vote for round 2. And you'll cross out anybody that wasn't chosen, so between Bruce Hinton, Carolyn Cassidy, Bob Sloat only got one. Did we leave him one? We'll leave him since one person selected him, but it'll be between those three people since they were the only ones selected for chair. So we'll go to round two, so cross out Betty Bingham and Marion Cody, and then select between, I'm sorry. I go, I put it back alphabetical order.
Betty,
Carla, I thought it was, you only proceeded with round two with the majority vote. Christie, is there something in the rules?
I'm gonna check.
Yeah, can you double check? It might just be between Carolyn and
Because
Hendon.
otherwise you're gonna keep getting the same
Yeah.
result.
It might be. So maybe no slope.
thank you.
Thank you.
I don't think it addresses
There's
round,
nothing in the rules.
round two. Mm-mm.
Does it say anything about that?
So I think it's gonna be much like a hung jury. You
Yeah.
gotta keep doing it.
Okay. Right.
Try again.
Round 34.
Okay, so we have, in each this time, 3 for Bruce Hendon. And then 2 for Carolyn Cassidy. So Bruce Hendon, 1 for the chair
We finished this
position, and then I'll
Oh, you do.
proceed
I think you.
and pass the ballots for vice chair, round 1.
Thank you.
Sounds like a boxing match.
Exactly.
Thank you. Script.
Where are we? Oh, we're trying again.
Yeah, that's what we started.
Okay, so we're gonna move forward to round 2. Carolyn Cassidy received 2, and Marion Cody received 1, and Bob Sloat received 1 vote. So it'll be between Carolyn Cassidy and Marion Cody for the second round.
Wait,
that was four?
only 4 people.
No, 2,
Yeah,
2 for Carolyn, 2 for Marion, and 1
Okay.
for Bob Sloat.
Okay, gotcha.
Okay, round 2. What time?
Thank you. Thank you.
Okay, on a 3-2 vote, Carolyn Cassidy gets the vice chair position, and 2 votes were received for Marion Cody. Congratulations to both of you, and now we just need a motion to select Bruce Hendon as chair and Carolyn Cassidy as vice chair as shown on the ballot.
I move that we select Bruce Hinden as chair and Carolyn Cassidy as vice chair as demonstrated by the ballots.
I move second.
All those in favor?
Aye.
Aye. Done. Bruce, your throne.
No, no, we- Okay. The proceedings are now called to order on agenda item number 3, a quasi judicial hearing to consider the administrative variance request for 6070 North Ocean Boulevard. Town clerk, please read the agenda item title.
An application submitted by Michael and Laura Lieberman, 6070 North Ocean Boulevard, Ocean Ridge, Florida, 33435, requesting an administrative variance from provision of the Land Development Code, Chapter 64, zoning, Article 1, District Regulations, Section 64-2, RMM, medium density multifamily residential district, paragraph E, RMM, medium density multifamily residential property development regulations, subparagraph 2B, minimum 15 feet setback, and Chapter 63, general administrative provision, Article 7, non-conforming and grandfather uses, Section 63-117, grandfather structure, paragraph D. 1, alteration, extension, enlargement, or expansion to permit the alteration and expansion of a grandfather structure by converting the existing garage to a den and constructing a new garage to extend it to the 15 side setback by 4.9 feet in order to align with the current grandfather structure property located at 6070 North Ocean Boulevard, property control numbers 4643, 4527, 10, 000, 0100, legal described as Coastal Shore Lot 10.
Okay. Thank you. At this time, any ex parte communication should either be disclosed by identifying the subject of the communication and the identity of the person, group, or entity with whom the communications took place, or any correspondence be provided to the town clerk and made part of the public record. In addition, each member of the board may identify the existence of any investigations or site visits he or she conducted, or any expert opinions received, and disclose any conflicts of interest on this matter. Bob, can we start with you?
I conducted a site visit, but I didn't speak to anybody.
Great.
I conducted a site visit. I did not speak to anybody.
I conducted a site visit and did not speak to anyone.
I also conducted a site visit, but did not speak to the owners.
I also conducted a site visit. but did not speak to anybody.
I
Well-
did receive an additional correspondence, and I do have a copy for each one of you. This is from Dina and Michael Fink, 6102 North Ocean Boulevard, Ocean Ridge, Florida, 33435. To whom it may concern, we are neighbors directly across the street from Mike and Laura Lieberman at 6070 North Ocean Boulevard, Ocean Ridge, who do not object to their request for a variance for their home renovation project. We hope that their request is granted. We are sorry we are unable to attend the meeting in person, so we are presenting this letter instead. Thank you.
Thank
And
you.
I can pass a copy to each one of you all if you.
Thank you. We will then proceed with the hearing on this matter. Will the town clerk please swear in the witnesses?
Okay, will anyone wishing to speak on this item, please stand?
Thank you.
Okay, raise your right hand. Okay, repeat after me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, when you come forward, please state your name and address clearly for the record. And whether or not you've been sworn in, just in case somebody comes after and has not been. Okay?
The town staff will now make its presentation on this matter.
Good morning, Chair, board members, Corey O'Gorman, the town planner. This is a request for an administrative variance for the property located at 6070 North Ocean Boulevard for the side yard setback for the addition of a garage as an attachment to the principal structure. The building official has deferred this request to the Board of Adjustments as provided in the town code and indicated in the memorandum in the agenda packet. The agenda packet also includes the background information from the applicant, including the application itself, and drawings to depict the request that is subject of the application, as well as comments from town staff. We're here to answer any questions that we can, and I believe the town attorney is going to provide you with some additional information on the administrative variance procedure.
Yes, thank you, Chair. So this one's a little different than your regular variance. This is an administrative variance. And as you may know, it came up recently at some town commission meetings that we've just amended the ordinance to try to clarify this. So the criteria that you're looking at today is the ability to expand a grandfather structure. And what that means by grandfather structure is that the structure that's on this property, when it was originally built, was properly permitted, but over time, the applicable codes have changed. And I believe in this case, the setback is the issue, that the setback became bigger through the town's code after this building was built. So it's considered grandfathered because it was built and permitted under the existing setbacks at the time it was constructed. Setbacks have now changed and now it's technically out of code, but we consider it grandfathered since it was permitted. So your two criteria that you're looking at today is to determine whether or not the encroachment that they want to expand upon, there's a limitation of 5% of the total setback area for the lot. So that's looking at all the total size of the lot, the total setback area, then doing some math and figuring out if they're 5% or less. The other requirement criteria that's in the code is that the encroachment cannot encroach more than 10 feet into any side setback. And that's a set criteria in this ordinance that's only dealing with the administrative variance. This recognizes that you have a grandfathered structure, so there is inherent in this a hardship because now their property in some respects have been squeezed by the new ordinance that creates larger setbacks. So if there's further questions, I'm happy to answer them, but those are really your two criteria for today.
Can I just add something really quick here? Normally, the building official looks at administrative variances and he will either grant or deny administrative variance. In the code, there's an option for him to refer that administrative variance to the board, and that's what he had chosen to do in this case.
And I don't know if you want to discuss.
Can I ask for clarification though, Chrissy, what you just said? You mean that they cannot go into the 10 feet, correct?
Right,
You
that
said more than
they
10
still
feet,
have to
even.
maintain it. Yes,
Okay.
sorry, if that
But-
wasn't clear.
Yeah,
They still-
and the other thing is you did mention hardship, but I thought with an administrative variance, hardship wasn't a factor that we're considering.
You don't. It's inherent that they have a hardship because they're a grandfathered structure.
Okay.
So they don't have to prove it.
I had one question. When they redid Ocean Avenue over A1A, a lot of the sidewalk was put on people's property by a foot. And I was wondering if this was one of the properties that gave up, allowed them to put the sidewalk on their property, which could be part of what the setback is. Do you understand where I'm coming from?
I understand where you're going because then the argument would be that their property was further squeezed by allowing for the sidewalk.
Which would change the math on it.
Yeah. I'm not going to get that far into math, but.
Okay.
But the front setback begins where the town's 5-foot right of way ends, correct?
So the issue here is the north end of the lot, not the east end of the lot.
Yeah.
It's not a corner though, yeah.
I just have a question, and I think it's for Mr. Guy. Why did you exercise your option to refer it to the board as opposed to making the decision yourself?
Thank you. So it wasn't as clear as the thing. The narrative stated that the north side of the proposed garage to extend into the 15-foot setback by 5.24 feet in order to align with the current grandfathered structure. And as you'll see, we actually had to send it back and ask for a revision because it does not align, nor can it. Because the original 10-foot setback, the property was actually, the house was actually encroaching into that original 10. So now it would be an additional encroachment upon that and the narrative does not align with what the request is from my point of view. As well as the questions about the garage. Should the garage now be a two-car garage to meet the new codes? So, there are a lot of variables that came up. And it's a difficult situation to put a building official in, because
Yeah.
I will also be the one reviewing this when it comes to me for construction. So, it's hard for me to allow something for a variance and then stop it on a building construction side. We're also looking at other things that may come up that have been mentioned. For example, the substantial improvement value that might be an issue later on. So just too many things that I believe that I have to be looking at. So I opted to allow the board to consider, if you guys could have a better perspective.
John, can I ask you a couple of questions? The math that you use to calculate, can you share that with us? So how much of the setback area is actually being infringed upon, and are we within that 5%
Then
with the proposals?
the actual portion of the structure that is within the setback is within the 5 foot.
Okay. And I know that you've gone over the substantial improvement language with the applicant, and that, granted, if you look at the Zillow estimate, for example, and then figure what the structure value is, basically 28% of the total value. I'm just roughly pricing it out. It looked like they could do up to maybe $200,000 in improvements and still be within that substantial improvement language.
That math is not correct. It's based on the actual structure.
I know,
And I did not dig that deeply into it at this time.
but I'm saying if they got a new appraisal that was in line with.
Again, I didn't go that deeply into it. Just based on other structures I've dealt with this type of improvement, that usually becomes an issue. So it was just to advise the
And
applicant.
you've advised them that this could be an issue when they actually go to.
Yes.
I have a question. I'm not a surveyor, but on the survey that's shown, it goes from 9'9" in the rear of the structure to 9'8" toward the east side of the structure. So it's cattywampus to the lot now, right? And it infringed on the original 10-foot setback when the house was originally built in 77.
They would have.
Okay, now the next line showing the east side of the proposed addition, it has it over 10 feet. How does a narrowing strip widen unless that they offset that wall? I don't know, but it looks like a straight line to me. So somebody's calculations are off.
I'm going to say that's not unusual. Again, as you said, the structure doesn't perfectly align with the survey. Sorry, the structure doesn't align with the property line. Obviously, it does start closer in the west, and as it goes east, it
Narrows.
It goes away, actually.
The property line or the structure?
The structure, right, the structure, my bad. The structure starts wider and then it narrows.
So, but then you see the next calculation at the east end of the proposed addition widens.
Oh, it doesn't. What happens is that in order to meet the administrative variance request, it had to jog. So the actual structure doesn't align with the original structure, which is one of my primary reasons for having this meeting today, sending it to the board, because it would not. And according to the original narrative, the reason for requesting this variance was to have a perfectly aligned addition. And based on the facts, it is impossible to have a perfectly aligned addition.
I see. Okay. Thank you for that clarification.
I have another question, maybe for Christie or for you, John. We're looking at two parts to the alteration of the grandfathered structure, right? We're altering existing and we're adding to existing. And we're not supposed to consider anything that's going to increase the nonconformity. But if you're looking at a one-car garage, the code reads it has to be a two-car garage. So how are we explaining, justifying, considering that?
Well, I could not. That's one of the reasons why you're considering.
And I think this came up upon staff, and that's why we had him open the den because technically it's not increasing nonconformity, the bedrooms are not increasing, and in this case,
Not with the alteration. I'm talking about the addition.
yes, well, technically the addition is not increasing nonconformity because the garage is staying the same essentially. And that was one of the debates that staff was having back and forth regarding to the garage, whether it would be increasing the nonconformity, yes or no. And I think Corey can add on more to this because I know we talked in length about it.
Yeah, I think that the addition itself is just for the garage structure, but of course the existing garage is being converted into a den space. And the discussion that we had was the language in the code allows nonconformities to exist so long as you don't increase the nonconformity. And the thing that triggers parking requirements is the number of bedrooms in the code. So if the project wasn't increasing the number of bedrooms, it wasn't increasing the nonconformity. So it's possible that by having one parking space inside in the garage, that it maintained that nonconformity and wasn't increasing it. Does that make sense?
Yes and no.
Okay.
The code says two.
Right. And that was the debate that we were having, absolutely. And was one of the reasons that the interior renovation to the den was modified so that it wouldn't qualify as a den.
What is the definition of bedroom in the code?
A room that has sufficient privacy that it could be considered as a bed or worse to that effect.
You have to have
You
windows.
have to have windows.
There's a window.
I know that. No, I'm just saying.
Well, that's what I'm saying. I mean,
Well, in most cases, we use a door to really define whether it's a bedroom. That's what staff has used also in the past for other applications, and it has to be equal across the board. So in other applications, we've always used the door to signify whether that would be considered privacy or not. And so in this case, they were originally planning to have a door there. And so in that case, we had to increase the parking space because it was considered a bedroom, but they removed the door, which would have allowed other applications to do and not consider that.
and we've, as staff, we've had this discussion. A door can easily be added after the fact and become a bedroom. So that's kind of, what we look at.
Question, can we restrict it to never become a bedroom? And if the house is sold or it is shown as a bedroom, what then would happen?
Well, if like part of your consideration to grant the administrative variance today is a condition that the den can never be converted, then that would run with the variance, which runs with the land. And then what would happen is if it were at some point converted to a bedroom and the town found out about it, the town would use code enforcement as them being in violation of their variance.
Would that keep them from selling the house or would it?
Oh, no,
make them
no.
redo it?
Well, it depends on how you word the condition. If you wanted the condition to just run with ownership, which is a little odd, normally it runs in existence, then the new owner would be subject to the same condition. If you wanted to do it further, one thing the building official and I were discussing before the hearing is that you can record a document in public records to put everybody on notice that the den can't be converted into a bedroom. And that would put any potential purchaser.
Because frequently this happens and the next time the house goes on the market.
Correct.
What was storage space is advertised as a bedroom?
Additional question. So we're extending the garage into the owned land. And I believe, is that part of the septic drain field for this property?
To answer that one, at this review stage, that was not a consideration.
Should it be?
Looks like the septic's in front of the front door.
Right, but they want to add a portico, you know, and when you add impervious coverings to part of the ground, I want to know if that was considered.
Mr. Hinton, also, if you want to open up to the applicant as well.
I will,
Have him come
but
up after.
sure.
He can go over it as well. Maybe he knows that it doesn't show the drain field.
Thank you, but I have this question to the town staff.
So with regard to the drain field,
Yes,
again, I don't recall us taking that into consideration at this time. We're totally looking at the physical dimension as to it encroaching physically. Again, at another stage, more reviews will be done. And absolutely, if this project does go forward and is approved, if that area is indeed drain field, it would have to be relocated properly to another area.
any other questions or comments of town staff? Then I'd like the applicant to now make their presentation on this matter.
Laura Lieberman, 6070 North Ocean Boulevard.
Same address, Michael Lieberman. No, when we started with this project, which has been going on for quite a bit of time, it was the idea of what was the best option for us and for the town, taking consideration with the improvements. So trying to keep the integrity of town and increase our livability, we thought the best thing to do was to modify what we have, or hope to modify what we have. The most logical thing and most cost-effective thing for us was to convert the garage into a den. There's no door into the den. There is no closet in that room. And there's access, which you should see on the plan, from the interior of the den into the garage, the new garage. I don't know how many bedrooms you've seen that have a door leading into a garage. I would say it probably doesn't exist. So therefore, we're not considering a bedroom for that fact. We're using it as an additional living space. When we're aware of the additional garage space that we needed to add, so we accommodated that by converting the existing garage into living space, adding the one car. And we did the offset that was required, the 3 inches, to put us within compliance. And addressing the drain field. The drain field is not actually the septic, which was on the image, is right in front of our bay window. To the left of that, and it goes to the other side of the house, is our drain field. We had it scoped out by Raider Rooter, which is a local company, and they identify where the drain field is. So this doesn't impact in any which way the drain field for this property. As you can see by the floor plan, it's an open access into the room, no closet, and then again, you go right into the garage. There's a back exterior entrance into the garage, but our main primary entrance would be from the den. So if it's a den, I mean, everybody has multiple rooms in their house. So if you're considering this to be a bedroom, which I hope you don't, then why wouldn't somebody's dining room, study, office, and family room be a bedroom in all of your homes? It would apply to everybody. So for us, it's a den, and I'm hoping you see it that way, which would allow us to have just a one-car garage and still be within compliance.
As far as a 3-inch setback from the north side, we would prefer that it be aligned with the current structure, because that seems to make sense. But we understand the 10-foot setback and not being able to do that. So I went through another revisions with the architect. I feel like we've done everything we can to try to make this house livable for us. And if we're staying true to what most of us say, we want to keep Ocean Ridge with a small town feel and not tear down all these smaller, more original structures and build very nice, but very large, more imposing structures. And I do think we have to really take into consideration these grandfathered structures because they're here. And people want to live in them, and we want to make them as family friendly as we can.
And we did present, Carla read the one letter from the neighbor across the street. We do have a letter from the neighbor who's would be most impacted by any construction we do, which is right next door. And they have no problem with anything, and they've reviewed everything that we proposed, and they have no objection to it. Nobody's voiced a negative, as far as I know, any comments towards the project. And it was sent out to with everybody within a 300-foot radius. So 0 negative responses. So.
Okay, thank you.
So I actually have a part 2 question. So if we're granted the variance, and I know Ronnie had brought up about the garage, can I assume then I then go with the building permit that the garage then won't be an issue? Like that won't come up as now we need if it's being addressed now, that the variance passes and the 1-car garage is adequate, then I go for the building permit. Is it then going to come up, well, now you need a 2-car garage?
Answer to that is no.
Okay. Any questions?
Can I ask a question?
Sure.
Given that you are in an AE, high hazard flood area, and I understand the neighbors next door are agreeable to the project, but they've only been here for several months,
Sure.
not during a heavy storm. Are you aware of any neighbors who would have a problem with this?
0, no. None. I mean, it's not the fact that we get along with pretty much everybody in Ocean Ridge for the most part. Might be 1 or 2 people who don't like us maybe, but for the most part, yeah. No, I mean, I don't really see anybody having a negative review of what we're doing. We're just trying to improve what we have and keep the integrity of the town. You know, in our vision when we're doing what we're doing, and to make sure we're doing everything with a permit. You know, we're not trying to do anything to skirt what we're supposed to be doing. We're trying to do everything the right way. I do wish we could have those 3 inches back, but I get that if it needs to be like that, we're fine with it. So,
Okay, thank you.
Thank you.
Thank you.
If any other member of the public wishes to submit relevant information to the board, may come forward and speak for a maximum of 3 minutes each. Please indicate whether you are for or against the project or neither for or against the project.
My name is Martin Wiescherleck, 5 Engel Drive. I'm going to wear 2 hats quick. First hat on, I'm a direct neighbor on this property. To the north also, we have the property that is directly to it, and I am kitty corner. We're basically sharing the cross line to it. We have no objections to this process. They have done pretty much everything that they could. They have reached out to me several times, asking questions. This has been going on for, probably 3 years that that the ideas have been floating around and what to do, and I always refer them to our building official, and they have really done everything what they can in order to make this house work for them the best that they can. So I, as a neighbor, I have no objections to this variance. Putting on my second hat as a commissioner, The reason why we had done this a couple of months ago, changed the ordinance basically where these grandfathered structures, and this was like the prime case for this, where these grandfathered structures come into play. We wanted to give the opportunity for somebody to maintain a visual line that is not aggressive in order to comply with the current code. So if you look at that little drawing there, that shaded area between the dotted line, that would have been the actual setback. So the structure would have been set back by 5 feet. In this particular case, the reason why you have this variance request here today, in this particular case, if this house would have been actually built by code back in the day when it was built, we probably wouldn't have been here, because it would have been right at that 10-foot setback. But this house was not just that it was built with the old code, it was also built wrong. It should have been 10 feet and they actually built it 9.8. So they built it wrong when it was built, but that's not their fault. And that's why you have this variance request here. The idea for us as a commission was and the planning and zoning board actually, from where it came originally from, we wanted to have one visual line in line with the existing structure if there was an addition. And unfortunately, in their case, they cannot achieve that because the house was built wrong. So now you would still have this little teeny tiny corner in there. And that's one of the things where you as a board of adjustments would come in and say, okay, we are okay with these extra 2 inches, 3 inches, whatever. And we're going to grant that because it makes the most sense in this particular structure.
Thank you.
Thanks for the clarification.
Terry Brown, Harbor Drive South. I don't need to say much after Martin. He pretty well covered everything that I was going to say. But from an architectural and aesthetic point of view, we have some pretty odd looking structures in this town. Right, Betty, going back years. If you stood on A1A and looked at that structure and they built it according to the setback of the current code, you would have this terrible looking structure. And in my opinion, it should go all the way back to the existing structure and make a smooth line, straight forward. It doesn't exceed the floor area ratio. It is a non-conforming structure. There shouldn't be any hesitation to approve it, as long as they're not going to use it as the old garage as a bedroom. Thank you.
Can I come back up just real quick? I hope I'm not shooting myself in the foot with this next question. But when I submitted the original drawing, it did incorporate those 3 inches. So we were advised to pull it back 3 inches to the south. Either way works for us. We prefer to have 3 inches so that everything is aligned and it makes way more sense. That was in our original request and drawings. So if you can take that into consideration, as Martin mentioned, this gentleman mentioned, that's our preference, and it just makes the most sense. So that's all. Thank you.
Thank you.
Can you consider that?
Well, I believe that's why staff initially told them that if you're going to pursue the administrative variance, there's the criteria that says they can't go with these 3 inches into the 10-foot setback. So that's why they asked them to revise it. So now technically this meets the administrative variance criteria. If you go back to give them the full alignment with the existing, and it's just a regular variance. And so, I think for your consideration is if you approve it as administrative, it has to not encroach in the 10-foot setback. If you want to consider having them go through the regular variance requirement, then you have the option to consider a further encroachment.
But that would involve a new application.
And
And
demonstrate
fee?
hardship.
Yes, they have to show
Yeah.
everything that would be required of a regular variance.
No.
Does staff have any final comments?
I know.
It's amazing that 3 inches is, and I totally get what you're saying, will take us from administrative full variance and then going through the whole application process again and delaying this even longer. Forget the 3 inches then, if you're considering it as a positive for us. But it's 3 inches. Keep that in mind. For construction, that's nothing. In house construction. And be perfectly honest, I'm an appraiser by trade. I'm certified in Florida and in Maryland, so I do both states. I've been appraising since 1989, done thousands of homes. And I can tell you that I've never been to a property where I've looked at it and said, it's offset 3 inches. Unless it affected the livability, it was a trip hazard or something like that, with steps, sidewalks, entryways. It has never come up on the exterior construction that 3 inches would impact anything on the property. And there's no documentation that can prove that out. Nothing anywhere.
Thank you.
Sorry. I had to jump in there with that.
I understand. Well, we're trying to get all the information we can in order to make a decision. Do you have anything else to add? Okay, good. Do any members of the board have any questions for the staff, the applicant, or anyone who has spoken on this item?
I have a question for Corey. So initially looking at this, my take on it was that it was increasing the nonconformity by allowing a garage that's only 1 car. But what I just want to make sure I understand you correctly, because there was a 1-car garage and they're essentially just replacing it with the same, that you're saying that that is not increasing the nonconformity.
That's correct. Yes, ma'am.
Go
I
ahead.
just had another question for Christie. So given that we're here at an administrative variance hearing, because we got here because of the 10-foot setback, there's no way we can do the 3 inches? With that, I wanted to see if there was a way through this administrative variance hearing that we could allow the additional 3 inches.
So this is what we're going to talk about a little bit later. You have your criteria,
Right.
and with the administrative variance, you really only have the 2 criteria. That's your criteria. That's what the town commission has set forth as your criteria. Now, you're setting as the judge for this quasi judicial matter. It's your choice to apply the facts to the criteria. If you believe, say, perchance, that perhaps this house somehow should be granted a further consideration under that criteria, I don't believe it's my role to tell you you can't do that. You're educated on the criteria, you know what the criteria, you're given a specific fact scenario that then you have to apply to that criteria. And that's when it becomes hard to be the judge, because you're the trier of fact and you have to apply it to the criteria to the best of your ability. Technically, the criteria is, as I said before, they can't encroach into a 10-foot setback. That's the technical criteria. And when staff looks at these applications, what we have to look at is we look at the criteria as well and leave the option up to the applicant. Do you want to go for a full variance? If so, then you could potentially ask for that further encroachment into 10 feet. Or if you want to pursue under this limited administrative variance, then you have to comply with the criteria.
But if they had to go for another variance and put off their construction for another period of time,
Correct.
and we don't have the option of changing what they've asked for.
We don't have the option. Correct. We can't change what they've asked for.
Where do we put a caveat that it remains a den rather than it becomes another bedroom? If we accept
Absolutely, you can put that condition on it.
We can put that into the motion.
Correct, yes.
I now declare this quasi judicial hearing closed. We will now proceed with comments and deliberation by our board. Bob?
My concern is that it remained a den and that it, I don't know how to word it effectively, but, you know, if the house is sold, it's advertised as a den. And that's my only concern. I would approve it with that caveat.
Betty?
I would approve it with that caveat, and this is the reason I brought up the setbacks in certain areas before planning and zoning made the setbacks larger was just situations like this. And I think where structures were built under certain criteria, they should have a right to use that criteria in changing the structure of the property as long as they stay within that criteria.
I'm a little confused.
This had a 10-foot setback.
Yes.
As long as they stay reasonable, I'm perfectly willing to go along with that.
Okay. Thank you.
Because that was the criteria under which the house was built.
I think the application fits squarely within the two criteria, so I would be in favor of that. My only regret is that we can't, for the aesthetic appeal, increase it by the additional 3 inches. Because I thought Commissioner Wysack was talking about what the commissioners wanted was a linear view, and that seems to be more consistent, is if it's aligned properly, that would ultimately get you to where the commission wanted us to be with regards to these.
Landscaping can soften that too.
Yes, but so that would be my concern, but otherwise, I think they squarely fit in with the requirements.
Carol?
I would be in favor of this. I think just emphasizing that it is not increasing the nonconformity by allowing this administrative variance. And, you know, my one particular concern is that front setback, because it is just perfectly with a new garage 25 feet from what appears to be the right-of-way property line. Now, the property lines along the road move according to the. So just as long as we're clear that that is in fact 25 feet. Yes, I would be in favor, and I agree with Bob that with the condition that that's not a bedroom, there will not be a door.
Yeah, I'm troubled by because it's a complicated situation, and it's nothing against the Liebermans. I understand 100% where you're coming from, but this isn't really about you. It's about the structure. Okay, and even though it increases your livability, the house was built in '77. You had no control of the building of the house under different land ordinances. However, you bought the house in '16 knowing the limitations of the house on the current property. The land ordinances most recently adopted by our council clearly states, notwithstanding the foregoing, no administrative variance shall be granted under this section that permits a structure to encroach within 10 feet of any side property line or exceed the maximum building height, blah, blah, blah. But I understand to be consistent with the structure that's already there to continue that architectural line, which is probably most pleasing to the eye. The other issue that's conflicting is, although you have all intention of keeping it as a den, I don't know what the next person's intentions are. So again, how hard is it to put a door and a closet in a bedroom? Probably could do it in an afternoon myself, and I'm not all that handy. So once that's done, that potentially affects the size of the garage that's required. And once a variance is granted, beyond code compliance, which, as far as I know, Ocean Ridge doesn't go into people's homes to make sure the codes are complied with, does affect the structure going forward. So I think it puts us in a difficult situation, and understand why Mr. Guy has sent it, because he didn't want to take that responsibility. But I think we have, it's not as clear cut as it may pretend to be.
Can I ask, the reason I asked the lawyer was there any repercussion if, when the house is put up for sale, there's an additional bedroom? Can you make them take it down, tear it out? Does the town have any ability to control that never being made a bedroom? And if advertised, it becomes a bedroom? What is our,
The recourse. So what you can do, as I mentioned before, is if the board feels strongly about it, we can record the grant of variance so that it's clear that this den can never be converted to a bedroom. I think what the chair is talking about is, yes, code enforcement typically is not done on the interior, and there would have to be some scenario where the town was given consent to come in. That could be through a building inspection, that could be through other inspections that happen, that we could find out that, oh, this was supposed to always be a den and not a bedroom, and then that would trigger code enforcement.
and the reason I ask this, there are at least 2 cases in town where it's supposed to be a storage area. When the house was sold, it was a bedroom, and we were told there was no repercussion, that, you know, the buyer didn't know that increased the FAR, et cetera. That's why, so we can restrict it.
Yes.
Okay.
Any other questions or concerns from member? I will now entertain a motion on item number 3.
I move that the administrative variance be granted to the Liebermans per their application, with the condition that the proposed den never become a bedroom. So it stay a proposed den. And also with the condition that the building permit plans be revised. I don't know if this would be appropriate, but based on Mr. Guy's comment that the building permit plans, they wanted a site data table demonstrating the zoning requirements? Or is that a condition of the building permit?
You can definitely say that, what, staff recommendations.
Yes,
You can-
because I wanted to incorporate the staff recommendation, if that's all right. So then the granting of the administrative variance subject to the proposed den staying a proposed den and not becoming a bedroom.
Would you like to ask for us to record a document showing that there's that condition, or no? Just
We can record the grant of the variance, which would have that condition on it, if that's what the board would like to do.
And that survives ownership, right?
Correct, because it will be an official record, so anytime the title work is done, that would show up.
Can we add to that motion the permission, the right of inspection by the building official at the time of the sale to make sure that it's not been converted without our knowledge?
That's a condition that I would ask the applicant if they're agreeable to that condition. Because you kind of, you could certainly put that as a condition. And knowing enforcement in this area is always problematic because it's an interior of the home. It's going a little bit extra further to then require, as a condition of selling the home, that the town be given the right to inspect. I think just we'll record the document, and I think that might be the best.
And I didn't want to put that in my motion.
Okay.
I just wanted, all I wanted to say was that in my,
I don't mean to
that the
interrupt you.
proposed den stay a den. That's it. I mean, I'm content with that in the motion. And the second part would be that prior to the issuance of a building permit, they would be in compliance with the requirements set forth by the building department, which is the site data table on the plan. So can we reference this document?
Yeah, so it's going to be, so your motion was to approve the administrative variance with condition that the proposed then never becomes enclosed. And that to follow staff recommendation to show compliance with section 64-1.
Yes, that would be it.
I'll second it.
Just a point of clarification, because this is an administrative variance, your motion is to have the north side of the proposed addition to be inset the required distance in order to maintain the 10-foot easement. Otherwise, it would be
It's consistent with their application.
consistent with their
Yeah.
application. Okay, okay, just for clarification. So everyone's clear on the motion, seconded by Mr. Sloat.
So let me call the roll call.
Can we take a, yeah, please.
Mary Ann Cody, how do you vote?
In favor?
Member Slow, how do you vote?
Aye.
Member Slow? Nay. Okay, Member Bingham, how do you vote?
Aye.
Vice Chair Cassidy, how do you vote?
Aye.
Chair Hendon, how do you vote?
Aye. Okay, motion carries 5-0. Do I have a motion to adjourn? Oh, no. Please, can I have a
Nice
motion?
try.
Please.
Sorry. All right, move on to, is there something? Yeah, no, thank you. What, time's getting late. What's
It is getting late.
I don't know.
One more item.
Yeah. Let's see. Wait. All right, next item on the agenda is the power and duties of Board of Adjustment when reviewing variances by Town Attorney Godot.
Thank you. So the intent of this presentation is just to maybe do a little refresher and then open up a discussion, because I don't want to talk for the next 15, 20 minutes on this, about the questions that you may have about the regular variance that you do. Because I think that we've all seen is there is a struggle between the criteria and the specific facts that are presented before you. So let's get into that. First, I just do want to go over some background information, so we're all on the same page. These are your 3 duties up on the slide. Obviously, the regular variances. You also hear appeals from the administrative official's decision. Just like today, you heard the administrative variance where the building official decided to defer to your discretion. And there's also a further area that you can authorize alterations to non-conforming and grandfathered uses. And that's a use change. Today, we are dealing with a structure issue. So next slide. Quasi-judicial, I wanted to just mention this to you. As I mentioned earlier today, you are the judge of these matters that come before you. That does require you to be impartial, certainly can ask questions, and then it's up to you to make the decision. And your decision is based on the evidence that's presented. And so just to make a point, in the hearing that you just had, none of the neighbors came and presented any kind of competing substantial competent evidence. So from that standpoint, and for a lot of the variances you hear, there is no competing evidence. So from a technical standpoint, the only evidence you have to consider is what the applicant presents. And sometimes when you think about this, it's a real struggle between the criteria and the evidence that you hear, because if the only evidence you hear is in favor for something, but it maybe doesn't meet the criteria, that's where it becomes a really hard decision for you to make, because strict application to that evidence is problematic because the evidence doesn't necessarily support all the criteria.
Christy, can I give a little example of what happened in this hearing? So in this hearing, the applicant stood up and he said, and by the way, my neighbor is in favor of this application. Well, that was hearsay. That wasn't really evidence. That was just hearsay.
There's a letter.
There's 3 letters.
We had one letter, but he was talking about the other neighbor.
No, there were other letters.
No, there were 3 total.
The other problem is most neighbors don't want to get into a squabble with their next door neighbor because,
But you.
yeah, depending upon the temperament of the next door
that's what
neighbor, they may have a gun.
But the letter did indicate there was a problem with
No,
the next door neighbor.
Chrissy,
Saying it was that.
in past variance cases, we have gotten letters in support and people say, well, they weren't here to testify under oath. So maybe letters shouldn't be admissible.
Well, that's a really good point, because the issue is if nobody shows up to contest the grant of a variance or the administrative variance like today, there's no challenge to it that it's hearsay. Now, in your mind, you can say, okay, it's an out of hearing statement that I'm not supposed to use solely for my decision. But if nobody's here to contest it, so if the other side shows up and they have an attorney and they say, that's hearsay, and unless you have some other corroborating direct evidence, you're not supposed to base your entire decision on hearsay.
Yes, but are we not supposed to decide whether what they want to do will be egregious to the surrounding neighbors that have to look at it?
That's one of your criteria, and we'll get into that. But I just want you to, as the judge, the hard thing that you have to do is think about the evidence presented. What Tracy's pointing out is correct. When they say, oh, all of our neighbors said this is great. Well, we don't have the neighbors here. And if someone were here to cross-examine him, then we might hear a little bit of a different story. That silence doesn't necessarily mean they agree to it. Silence means they don't want to perhaps create a dispute.
You heard my
with
statement.
I just
I
wanted to,
asked if they were aware of anyone that was not in agreement, and they said no.
Right. And we do, and that's let me just move on to the next slide, just so, I think it's further down. The notice requirements. We do notify everybody within a 300-foot radius. So you can be assured that the notice has been given to the neighbors. So if someone feels strongly about it, they would have the ability to come here and have their say. They may not.
my question is, when they submit signed letters as part of their application and they swear that their application is correct, right? We can rely on those letters because
You can, to an extent. If I were an attorney that showed up that was on the opposite side and I wanted to object to the application, I would hold up those letters and say, I don't have the ability to cross-examine any of these people that wrote letters. So all of those letters are technically hearsay. So I don't have the ability, so to make your hearing completely fair, right? I don't have the ability to cross-examine them to say, now, are you aware of all the intricacies of what they want? Are you aware of this? Are you aware of that? And sometimes, obviously, as you know, when you do cross-examination, someone might go, oh, I didn't know about that, or I wasn't aware of that. May draw out some different facts or opinions. But if nobody contests those letters, you're absolutely right that the applicant gets up and says, I've talked to my neighbors. I've got other neighbors that have written letters. Nobody says they're against it. That's probably true.
What about if the applicant writes all the letters and asks the neighbors to sign it? And the neighbors sign it because they think no way in the devil will this go through, and that's the response I got.
That's another thought.
We can expand on that and say we also are relying on evidence presented, and if we don't get a complete package or truthful evidence, then that impedes our ability to make a well-informed decision.
Correct. So just going back to the presentation, one thing I want everybody to be aware of, if you're present for the hearing, you have to vote unless you have a conflict or the appearance of a conflict. Now, if anything ever is on the agenda where someone thinks, oh, I live next door, or, oh, I have a concern with this, that I might have a conflict, please let us know beforehand. Because you're under the Palm Beach County Commission on Ethics rules, which mean if you have a conflict, it's not just you can't vote, you can't participate. So we really need to know before the hearing if you're gonna have a conflict, and then we can make sure that you're not participating, that you're not gonna vote. And if it's a close call, sometimes in fact, we might go to the Palm Beach County Commission on Ethics and ask for a written opinion. But if that comes up. So just be aware when you look through the agenda, if you're like, oh, this is my neighbor, give us a call, we'll talk through it. But if you are present, you have to vote, and that's by Florida statute. If you had to go to the restroom and you're not present, that's a different story. Which if you ever watch like local government, all of a sudden people get up and they leave right before a vote.
Thank you.
Another question on letters. Letters from neighbors are one thing. How about letters written on professional letterhead by engineers or by professionals that are certified, registered, whatever,
right.
And require certain knowledge and experience subset in order to practice professionally. If I receive a letter on their letterhead signed by them, I take that as gospel. Do they need to be present?
If whether the letter's from a neighbor or whether it's from a professional engineer, it's all hearsay. So technically there needs to be some other direct evidence that corroborates what they say in their letter. A lot of cities, sometimes variances or even before your planning and zoning board, quasi-judicial hearings can be very contested. And if an engineer writes a letter, my advice is the engineer needs to be at the hearing and needs to be placed under oath, because if anyone's going to object, they're going to want to say, I need to cross-examine that engineer. In litigation, both sides are going to get an engineer and they can have very different opinions on the same issue. So whether or not it's on professional letterhead or whether it's a letter from your neighbor, it's all hearsay, and if you don't have the chance to cross-examination, you might object to it. Therefore, that's why they say in the quasi-judicial realm, where it's not strict rules of evidence, there should be some other evidence to support what they're saying. So an example would be if the engineer said, this is the only safe way to construct this, right? If the applicant or other people from the neighborhood could also come and testify before you and say, yes, I am aware that that's unsafe, an unsafe condition. And they do that based on their personal knowledge of living in the neighborhood for 10 to 15 years and seeing this unsafe condition. Then you have that direct evidence that would help corroborate that letter from the engineer that also says it's unsafe.
One thing that has not happened as long as I've been part of this board is stopping the process, saying, well, they're not here, until they appear, we can't make an informed decision. Is that within our realm?
You could do, which is what we've done with Planning and Zoning Commission, is defer if you have specific questions and you want to, the professional who wrote the letter, you want to talk to that professional and get direct evidence. You could certainly defer, and I think some of your scheduling is a little bit more ability to perhaps do it rather than just once a month, perhaps have a shorter time frame, knowing that oftentimes the applicant's waiting to move to construction documents or something like that and short that time frame. But yes, that would be within your realm to say. The other thing you could say is, all I have is this hearsay evidence in this letter. If I don't have any direct corroborating evidence as to what they're saying, I don't have substantial competent evidence. And that is your standard. And I have the definition in here. And basically the evidence needs to be relevant. It needs to be material, and it needs to be something that a reasonable person would find tends to prove a fact. And that's what you're looking for. So if it's just hearsay and all you're making your decision on is a letter from a professional, I would say from a legal standpoint, it's not enough evidence. And you need someone to come in and give you direct testimony. So if you wanted to say timeout and the board, there was consensus to do that, I would say that's within your power.
Thank you.
question. If a professional, electrician, a plumber, or a lawyer writes an opinion, do they have to say, well, do they have any interest in the property or?
Well, right. It's a good point because oftentimes it is the architect, the engineer, or someone who is involved in the ultimate construction project that the variance is needed for that is providing that opinion. And that's not unlike regular litigation where the person who's testifying does have an inherent interest in the matter. So yes, and certainly if they're here and present, that's something you can ask them about that, right? Were you paid to develop these plans? Were you paid for this opinion? So yes, certainly. All right, so let's just go back to this. I don't want to make this too long for everybody. This is on the ex parte communications, and just so you know why we do this at the beginning, is just to make sure everybody's on notice of what you know personally about the issue, what the applicant knows, and what staff knows. So it makes sure that everybody has due process. One thing I just want to make you aware of, it during your ex parte disclosure, if there's something that you say that could be potentially problematic for a record on appeal, I might have to ask you more questions to say, okay, you've disclosed you spent 2 hours with the applicant talking to them. Based on that communication, are you still able to sit as an impartial member and hear the evidence before you and make that decision solely based on the evidence? I might ask you a couple questions like that, and all I'm doing is I want to preserve, if we ever saw an appeal from your decision, that you said on the record, I can still be impartial and I can hear all the evidence. It doesn't come up much, but every now and then it will come up, and that's something that you just have to get further clarification to support your record. Like I said, there's no strict rules of evidence. If we go to the next slide, there's no strict rules of evidence, but you need to make sure that everybody is given the due process they're entitled to. If someone objects, if they show up, the next door neighbor wants to object, they do have the ability to also cross-examine the applicant and cross-examine any of the applicant's witnesses. Public participation, just so you know, we don't put the public comment folks under oath. I know Commissioner Reschelek he swore today. But oftentimes if you have public comment, it's not evidence. There's a gray area there because, like I said in my example, if you're a neighbor and you've lived in the neighborhood for the last 15 to 20 years, you're not maybe just providing public comment, you're providing factual statements. And in that case, I would ask the person to put under oath because they may be providing evidence that sway your decision one way or the other.
So when a commissioner speaks and they don't have a vested interest in the application other than the fact that they sit on the town's commission, that would just be, that wouldn't be considered evidence, that's just public comment.
Just public.
Is there, because the weight of their comment is usually greater because of their position. And I find that troubling when you see them come up and give an opinion. It has more undue influence and they aren't really there, to be part of the evidence.
I agree, Mary Ann, and haven't you dissuaded them from doing just that?
When there's the potential that the issue will come before them for a decision. With this board, the only thing that could happen is that it gets appealed and it goes to circuit court. There's not an appellate step that goes to the town commission. If there was an appellate step that then came to them, I would say you better not make a comment in front of the Board of Adjustment, otherwise you may have to recuse yourselves because they have to also be impartial. Would they be an appellate authority of this board? They would have to be impartial, and if they got up in front of you and said, you absolutely can't do this, they can no longer be impartial. So I'm okay with comments before the Board of Adjustment because they'll never hear it at their level. But your point is well taken.
Don't they have the option of going back to town council?
No, not what your decision.
You go to district court.
Yeah, what your decision.
Right, but, okay. Okay.
They could go to public comment and complain to the town commission that they didn't like your decision,
Right.
or that you made a great decision. But then it's just public comment, and then the
Yeah,
commission doesn't
yeah,
take action.
exactly. That's what I'm saying. Of
My
course they can.
concern is
And they can
given,
also ask for ordinance.
given
to be
their
rewritten.
role,
You know, they didn't get a variance to the current ordinance, but they can go back to have the ordinance rewritten.
Oh, absolutely,
Right.
absolutely, absolutely. So,
So they can go back before council.
well, they would have to go to ask for a text amendment to change it. So if a commissioner comments here about he's for or not in favor of something, and the result then requires them to change the code, that's always going to be within their purview. But to change a code, it's not just one person on the commission, obviously, it's
Right.
the entire body. So it's harder to just make one comment here, and then they have to convince all their colleagues on their board.
my concern is more the undue influence it has, their testimony, on people that are actually here, you know, witnesses complaining, neighbors, and things like that, that are part of the evidence we're considering. That kind of jeopardizes, or not jeopardizes, but actually sways some of that evidence that we're hearing.
You're absolutely right. You're absolutely right.
If he spoke as a commissioner, and as a commissioner, he went through ethics training. Is he a commissioner when he speaks as a commissioner at this meeting?
He is, he's not speaking for the commission. He has no
But-
authority to
but-
speak for the commission.
But he is a commissioner,
He's speaking as
and he
a
can't tell the truth.
Well,
As a
he
commissioner.
took an oath. He stood up when all the witnesses stood up,
Okay.
and he took an oath,
And
so.
he said he was wearing two hats.
Right.
The first part was as a neighbor, and the second as a commissioner.
Commissioner.
Yeah.
So he did speak as a commissioner.
Mhm, right.
Which
the two are hard to separate, quite
Right,
frankly.
yeah.
And, but just keep that in mind. If there ever comes up a question, I might point out this is just public comment. That
Okay.
It's not to be construed as.
That's a good thing, Christy, to be able to do that,
Yeah, okay.
to help.
If we go to the next slide. Okay, so this is what I was talking about the evidentiary standard. Competent substantial evidence. That's sort of the definition right under it. Again, is the example of hearsay. If you want, we can go back through that, but I think we sort of talked about that before. The next slide is the board's motions. Obviously, when you're approving nowadays, I think it's become kind of fairly standard to do conditions, which I do recommend, because that also helps to make it clear, as the chair said earlier, we don't set precedents by variances, because variance is very fact specific to the application, it's specific to the land involved, and it's specific to the evidence you hear, which can be very different even if the application is essentially for the same thing. So when you're doing a motion to approve, you obviously can do that with conditions. What I would recommend is when you're doing a motion to deny is to specifically call out the criteria that you don't believe it satisfies. And that's, again, just if it ever were to be appealed to circuit court, you could stay on the record that clearly it didn't meet this criteria. Now, if it's just generally that it's not a hardship, that you could say something like that, but it's helpful if you're denying the application to say why.
What about the not really telling the truth and the whole truth? It's circumventing the facts.
Well, let's talk about it a little bit, because you're looking at the criteria, and we're going to go through the criteria real quick, but you're really focused on that criteria. Now, you're going to hear perhaps evidence that someone already went and did it. They did it without a permit. And you're going to hear those types of things. But when you think about it, all of that sort of extraneous evidence, it's not part of the criteria. So whether they've actually constructed it, whether they've been a bad actor, whether they have a history of code enforcement with the town, it's actually not part of the criteria. You're just supposed to be focused on the criteria and the evidence presented. So even though you may be presented with a bad actor, that may not necessarily mean that they shouldn't get the variance, because it could still meet the criteria.
Can I ask a question about that, though? For example, the history of code enforcement issues. I think that's material and provides context to us in making a decision about a specific case. If there's a history of somebody having had violations or trying to get around the rules, that's material, I believe. Do you not agree?
It's not in your criteria, and it's something that some people on the town commission also believe as well, that perhaps our application should lay out, what their background is. It's actually not part of the criteria. Your criteria is governed by what is listed in the town code. That's the legislative action that the town commission took to set forth the criteria that you apply. So if there's a strong feeling that part of that criteria should consider someone's past history with code enforcement, with building permits and those types of things, then that may be some type of text amendment that you want to consider recommending to the town commission that they consider, because I know you're going to have support from, at least one member of the town commission that they think that's also material. But right now, the way your criteria reads, it's not.
Okay.
Even with all that, what they present to us, they have, sometimes there's no real good reason why we should permit it, except for the fact that the person wants it.
And that's getting more into your criteria. Let me just run through really quick and we'll get to the criteria, because I think that's where the heart of the matter is. Obviously, with our applications, they're filed with the town. We have our set application that they use, and they do swear to the information in their application being under oath. Next slide's about the notice that's provided. As you can see, there's ample notice provided regarding the variance. So if anyone ever comes before you and says they had no idea, that should be a surprise.
Christy, can I just mention on this, we talked about this in the town commission meeting about the notices that go to the affected property owners within 300 feet. We had talked about in the town commission meeting, kind of beefing up that notice to say that if you wish to cross-examine or do anything in that hearing, that you should provide, or you should come with an attorney.
Yeah, and I think that's a good idea. Some bigger cities, they have a whole procedure that lays out if you consider yourself an affected party. So usually the property owners within that 300-foot radius are affected property owners. Now, affected usually means something about the proposed variance is going to impact them one way or the other. Oftentimes, other cities have a process where if you believe you're an affected property owner, you can apply so that at the hearing, you're given the same rights as the applicant. That means you can come in with your own witnesses. Ideally, you come in with an attorney. You can cross-examine the applicant's witnesses. Just because you live in the 300-foot radius doesn't necessarily mean you're an affected party. Sometimes you're not really going to be impacted by the project, so you may not be affected, you might be interested. But this way, I think if we do something in our notices to notify people, to give us to let us know if they believe they're an affected party, and also that they should hire legal counsel, which I think is helpful, because an attorney that does this, they know the standard. They know when something's hearsay and that they should challenge it and those types of things. And that's why I always recommend legal counsel, just because they're more familiar with the standard.
How soon do these notices go out prior to the board meeting?
I think it's at least, I know 10 days before.
So 10 days, so, you get the notice, you go, okay, I want to have an adversarial opinion. 10 days to go and find an attorney for them to do their due diligence to represent you.
That's not a lot.
That's
It's not a
nothing.
lot. And oftentimes what I would do in that scenario is if someone says, I've just been retained, it's 3 days before the hearing, I would ask for the hearing to be continued, because it is a due process issue. And if you take action at this board and if someone has a good argument about due process, we're going to get overturned on an appeal. So I would rather say, okay, let's give them, how much time do you think you're going to need, and reset the hearing so that they have ample time to prepare.
We were faced with that 2 years ago. The attorney asked for a continuance and the board denied it. And I think they did appeal based on that, yeah.
I think you also need to educate the people
I
in the
forgot that.
town. I
Yeah.
don't think most of the people in the town have any idea that they could come and make a.
Right, and so that's what I think we're talking about, beefing up the notices a little bit, so to make it more, so people know, you can come, you can give public comment. If you believe you're an affected party, contact us, and, legal counsel's always recommended.
Oh, when we pass a bad decision because of whatever, then what do? They take it to the state or they take it to the.
Appellate court.
It goes to circuit court.
or circuit
It's
court.
called a petition for writ of certiorari. And once the order is issued, so what happens is you guys make your decision, and then Carla prepares the actual order. When that order gets sent to them, that starts their 30 days. Then they have 30 days to file that petition with the circuit court. And it's an appeal. It's an appeal of your decision. What the circuit court's going to look at is to make sure that you gave them due process. So you gave them a fair hearing. They're going to make sure that you acquired the essential requirements of law. And there's one other standard that just totally escaped me. There's one other standard, but they're sort of limited in their review. Their review is the record that's made here. It's not an appeal de novo, meaning that they can now argue everything in the kitchen sink. It's limited to the record created before you. So that's why sometimes I might say something or do something, and I'm just trying to protect the record, because when it goes up on appeal, that's all that the appellate court has to look at. So, there's a lot of words on the next slide. This is, and I don't like to usually read slides, people. So I've underlined a few sections, because what this is saying is this is your basic standard, and the criteria sort of spells this out, but this is sort of a good summary of what you're looking at. And the focus is looking at a hardship, and it's based on the size to be subdivided, the topography. You're looking at adjoining areas or some other unusual physical conditions to grant the variance.
Excuse me, may I be excused? I have another commitment.
Okay.
I will take this.
Okay.
Thank you. Thank you.
So what I do want to point out is that the first step in looking at application from staff is staff looks at these, if you go to the next slide, Carla, staff looks at these first 4 criteria. Now, these are going to look familiar because these are the same criteria that you're going to look at. But staff does have the ability to not process an application. Now, what I've told staff is, if we don't process an application, then they're going to appeal it to the Board of Adjustment to challenge the administrative official's decision not to process their application. And so then what happens is essentially you have to decide the variance, even though staff says we're not going to send the petition forward. So I said, my best recommendation in practice that I've seen is if staff doesn't believe it meets the criteria, staff could, 1, recommend denial. Staff's presentation can say, we recommend denial, or staff can just forward it and say, here's all the criteria and here's staff's analysis that the criteria may not be met. Staff is solely looking at the application. What the application says and what happens before you, which is the evidence that you're making your decision on, can often be 2 different things. So while we can look at an application and say it doesn't meet the criteria because they did a poor job of filling out their application, they could come in here with their engineer, they could come in here with their architect and actually make a very good presentation to you as to why it should be granted. So my recommendation is to just move the application forward because it's going to get to you one way or the other, quite frankly. But we do look through the initial same criteria. And if we go to the next slide, we can go through some of the criteria, and I know everybody is a little short on time. You have the presentation. If you get familiar and comfortable with these criteria, you can always bring your presentation with you. But the first 2 here I put on the same slide because they're essentially saying that staff has looked at it and meets the application. So you're really, these two are sort of what I would say just procedural criteria. So if we go to the next slide, this is a big one. And this follows that language, the summary language, where it's something peculiar, something unusual about the property, about the structure, that is not, you're not finding it typically in other districts or with other buildings in the areas. We go to the next slide. Obviously, there's got to be special circumstances that kind of builds off the last one. If we go to the next slide. Conferring a special privilege that's denied to others. Now, here's where I have some heartburn with the criteria, because some of these criteria you read, particularly this one, it almost seems to be inconsistent with the other criteria, because on the one hand, you're saying there is something peculiar, but then it's denying, it's giving them a special privilege. Well, yes, they would get a special privilege because of the uniqueness. So what I'm pointing out is you have to take all these criteria at a whole, and sometimes really just look at it from a hardship standpoint, because if you really dig into the words in each criteria, they seem a little inconsistent. If you go to the next one, literal interpretation could deny them a right commonly enjoyed by others. Well, the mere granting of a variance violates this criteria, even if they have a hardship. So what this criteria, other ones are trying to do, is to focus in on what is peculiar, what's unusual, what is the hardship that makes this property, this building, this structure stand out, that you should say, let's deviate from the legislation that we have before us.
Yeah.
We go to the next one. This one is sort of building off of number 6, but again, focusing on the undue hardship on the applicant because of the physical structure. And next slide. This again, number 8, this is where we look at trying to develop conditions. If you're inclined to grant them the variance, this is the minimum variance necessary to do what they want to do. And this is where your conditions come into play. That if you're going to grant this variance, we're going to do it with these conditions X, Y, and Z, so that we limit the scope. You limit the time frame if possible, those types of things to make it more reasonable and consistent with the underlying legislation. Next one. The harmony with the general intent and purpose of the land. Obviously, one of the things they were arguing in the hearing earlier was that this would keep this building, the structure, looking consistent with how it existed, keeping it in harmony with other similar structures that are non-conforming in the area would be the argument if that were to go to a full variance. And finally, the injurious criteria, you want to make sure that it's not going to injure any nearby neighbors, and it's obviously always has to be consistent with the comprehensive plan. Your comprehensive plan doesn't get into too much detail, so usually it is going to be consistent with the comprehensive plan, but that's something that staff will check as well. So one thing to do, looking at those 10 criteria, is as you're sitting in a hearing, is if you condense the presentation down, is just to remind yourself as you're going through that the 10 criteria have or have not been met. Certainly, like I said earlier, if you're going to make a motion to deny, you can pick out a criteria that it doesn't satisfy, or just simply say it doesn't satisfy any of the criteria. Couple other notes in the code for the variance is that obviously you cannot consider a financial hardship alone. Oftentimes you might hear a variance where they're going to construct it a certain way and they say that's to make it cheaper. That alone is not a hardship. This is a use. Now, we haven't had one, and you guys don't have them often because you're pretty much residential area. You don't often have a variance requested to use, but that's if someone, say, wanted to build a duplex in a single family neighborhood, that would be a use variance that they would be seeking. But you can't use the variance process to do that.
That would be completely overlooking an ordinance.
Yes, but all variances really are. But you can't allow a use variance under your code. These are also some very long, lots of words on here, but I wanted to lay out what you can do with your conditions, obviously, to minimize the variance that's being granted. And you can put time restrictions on how quickly they need to do it. If you don't, it's a 6-month time frame from when they get issued their building permits. If they exceed that, they would have to come back for a new variance application. And go to the next slide. So I ran through it fairly quickly. I know that we had 2 things this morning that kept us for an hour, but it's just to refresh this, keep it in the top of your mind. It is a very hard thing to sit up here as a judge, knowing that this criteria virtually makes it impossible, but you have to temper it with the evidence that you receive. And that evidence really will dictate sometimes how that criteria gets applied. So I know oftentimes people might, criticize the decision or something like that. Unless they're in the hearing and they hear how the evidence is truly presented or what counter evidence there is, it's a very hard decision to sit up here and be a judge of your neighbors. But try to keep in mind the criteria that we're always supposed to meet. And if you believe that it kind of meets the criteria, then rely heavily on your conditions to minimize the impact of that variance. Any other questions?
Well, I think understanding the overall town, part of the town became part of the town when none of the lots were conforming. And therefore, a lot of the rules and regulations were written to try and force people to upgrade the properties a little bit, but not overbuild them. And other than that, I think we need to be pretty consistent with rules and regulations. Otherwise, we'll slowly but surely make our city overly built so that you don't have any open spaces and breezes and sunshine and dogs running and whatever.
Any other comments or questions?
Can I comment? So it's very common, or especially the board, planning and zoning boards, to actually ask if they could have 10, 15, 20-minute meetings with me, and I do my best to be impartial throughout the entire process. What I do is extremely technical. I mean, I depend on dozens of manuals each day to make decisions, and when it comes to you, we kind of condense it down. And we know that when we summarize something too much, we lose a lot of the essence of it. So I just throw that there. I'm available. Call me up. I'll do my very best to provide the board with the necessary information and background to rules and codes and laws that govern the consideration that's about to happen.
Your job's harder than ours.
And one thing I would like to say on that is if you take him up on his offer and you meet with him to go over a variance, please disclose that as an ex parte communication, because technically the town is a participant, just like the applicant. So if you do meet with town staff, make it part of your disclosure so that the applicant's aware of what additional work you may have done to understand the variance.
So in looking back at the case that we've already closed, do the sunshine laws apply to us talking about those?
So if a case has closed, usually you're fine to talk about it. The problem is it creates an appearance, and that what I have to advise against is creating even an appearance of a sunshine law violation.
Okay.
And so once you've made your decision, that same decision would rarely come back to you because it's going to go to circuit court. Now, if it gets overturned at circuit court, it could come back to you in some capacity. So there is a slight risk that it could at some point come back to you, but it's that appearance. And so when you are seen together talking about, oh gosh, you know, I think we decided that great. I think that was a great way to decide that. Someone hearing that who may not know the intricacies of the Sunshine Law and may just think it's creating the appearance, that may cause, you know, a complaint to come forward, and something that would best be avoided by just keeping it, you know, straightforward, and you don't talk about a decision even if you've decided it already.
Okay.
Well, speaking of appearances, if the Board of Adjustment has made a decision in a case, but it's brought back up before the town commission, isn't that an appearance of the abilities of this very board? We can't discuss it, but other people can.
Oh, absolutely.
So should that be allowed, or should that not be allowed?
Well, if the Sunshine Law governs 2 or more board members on this board from discussing something that will foreseeably come before them for action. So you can't discuss it, but town commissioners, the mayor and vice mayor could sit down and talk about every single Board of Adjustment decision that's been made as much as they want to, because they're not governed by the Sunshine Law for this. Now, the problem for them is if that ever in some capacity came before them, they've now created their own appearance of a Sunshine Law violation. So you're right. It's problematic because you're never sure, certainly from a town commission standpoint, if it's going to foreseeably come before them for some type of action, like we discussed earlier, a text amendment. Something you decide here as a Board of Adjustment may make the town commission say, you know what, we should change that. And if they've, 2 or more of them have had that discussion outside, you know, the sunshine on that, then that technically is a Sunshine Law violation. So they've got to govern themselves, but they could certainly talk about what happens here, and it wouldn't be a Sunshine Law violation for them unless it were something that comes before them.
Can they beat up on us for the decision we made? I mean, can they talk to us?
It goes both ways.
Both ways, right.
It goes
I
both
mean,
ways. I
yeah.
mean, you can certainly talk to that you didn't agree with something the town commission did. You know, if they're going to change your criteria, or they're going to change something in the code based on a decision that you made, you have the opportunity to show up at public comment before the town commission and say your piece.
I was approached by someone after we made a decision to deny the floating dock. And the person asked me why. And I said, I'd rather not discuss it. Could I have discussed it?
If it's just someone from the public that wants to talk to you about your decision, you can talk to them about that. Absolutely. You're not, if the Sunshine Law requires 2 or more board members talking about something that will foreseeably come before them for action. So if it's just you and a member of the public, you're allowed to. You can actually talk to a member of the town commission, and there's no Sunshine Law violation because you're not on the same board.
So you have a third party talking to 2 or 3 of the people on the board through
A conduit. You're talking about a conduit. You can't use conduits. You can't talk to a person and that person runs and talks to another member, and that person runs and talks to another member. That's called being a conduit. That's also a violation of the Sunshine Law. But sometimes
You can't use staff as a conduit.
right, you can't use staff as a conduit, but you know, as you may know, we have the individual meetings with each town commissioner before the town meeting. We can meet with them one-on-one. What we can't do is what we talk to the mayor about, then talk to the vice mayor and say, well, the mayor told us this, because then we're being used as a conduit. And we have to police ourselves so we don't do it, as well as the commission has to make sure they don't. So, because obviously if you violate the Sunshine Law and it's related to a decision you make, that decision becomes void. So then you have to redo it all over, so.
That's been asked of us a couple of times in our staff meetings. A commissioner will say, well, what do my fellow commissioners think about? Well, we can't tell you that.
Can't tell you that.
You'll find out.
Right. So, Board of Adjustment in every city I've ever worked is never an easy job. Because obviously you're human. And it really is dictated by the evidence that's presented before you, whether anyone, shows up to object to it or contest it. So it's a hard decision, and unless someone sits in every decision that you make and listens to all the evidence presented, and comes to the hearing with your background and your experience, it's a very different decision for each person. So it's not an easy job. You have a hard job. The easiest way to do it is to say no to every variance, but then you kind of make yourself obsolete. And I don't think we'd have a board of adjustment if we didn't need you guys.
It's not a
So it
popular
just keep in mind, it's a difficult decision. Being a judge is very hard.
Yeah.
It's very hard. So I commend you for your your duties and what you do. If at any time during a hearing you have a legal question, I'm more than happy to answer it. I don't believe my role is to tell you whether or not your decision is legal. That's what a judge would do if it ever got appealed. I will tell you the legal standard, I will tell you the criteria, but it's up to you to apply the facts to that criteria. That's your role, not mine.
Thank you.
You're welcome.
Mr. Chairperson, I move we adjourn.
Okay.
Do I have a second?
Second.
Do I have any nays? Meeting adjourned.
Thank you.